facing increased and discriminatory security assessments based on nationality, family ties, religion, and history, and being denied employment and travel based on these secretive and unsupported grounds. Underlying all this has been the malleability of this vague term of terrorism, and that's a big focus of our work at the coalition. Because under the Canadian Criminal Code, an act of terrorism is pretty vaguely defined as an act or omission committed for a political, religious, or ideological purpose or cause, with the intention of intimidating the public with regard to its security, or that it causes death or serious bodily harm, endangers a person's life, or even causes substantial property damage. And so while there's specific examples of what a terrorism act is, it's, the fact that it's based on this idea of political, religious, or ideological purpose means that's incredibly malleable based on what the concerns of the government of the day are. And we've seen that over time, and how it's been used to target, particularly the Muslim and Arab community in Canada, but also other communities. And on top of this, anti-terrorism laws are primarily preventative. So that means that they're meant to be enforced before a violent act is committed. And so on top of a vague definition, what we see is attempts to predict and prevent, primarily in secret, future crimes. So what we've seen is the growth of powers, especially for the Canadian Security Intelligence Service, to disrupt acts secretly without having to reveal it publicly, either to the target or to the public. And only in very limited circumstances do they even need to go to a judge to receive a warrant to be able to carry out these acts. The only form of reporting that's necessary is after the fact, the National Security and Intelligence Review Agency. And even in those cases, it's not rendered public afterwards. And they've even raised questions about the degree of honesty and frankness that CSIS has had towards them in sharing the work that they're carrying out. So because of this, as I said, the idea of what is a terrorist or a supporter of terrorism can be molded to fit the political interests of particular governments. And also provides wide leeway for security agencies to investigate and disrupt those who they believe to pose a terrorist threat beyond public scrutiny, and cast a wider and wider net. And this is what we've been dealing with in terms of, what's known as the anti-terrorism and national security creep, where everything becomes, an issue of security, where these agencies, instead of saying, well, we've addressed a harm, we can actually pull back and condense the work that we're doing, refine the work that we're doing. Instead, they're always looking for more and more information, more and more powers to be able to carry out their work. And this is regardless of, the types and incidents of actual threats and violent activities that happen in Canada. And so that's what's led to the types of human rights and civil liberties abuses that we've seen committed in Canada in the name of counterterrorism. This includes rendition to torture. This includes, surveillance and the collection of Canadians' private information illegally and without their knowledge. It includes the detention of Canadians abroad under circumstances of torture and abuse with Canada's complicity. And it also includes Canada's participation in the broader war on terror and the abuses that we've seen through that. There's also an issue at the global level. It's clearly not relegated only to Canada. And just recently, the UN Special Rapporteur on Counterterrorism and Human Rights issued a report on the misuse of technology for counterterrorism purposes, and wrote that, and I quote here, that abusive practices are hardwired into the counterterrorism and countering violent extremism arena, precisely because of the absence of agreed international definition of those phenomena. So it's not just Canada that's struggling with the idea of what's the definition of terrorism and how it can be used and misused, but it's also an international issue where there's no globally agreed upon definition of what is terrorism. And in instances where there are definitions, as in the case of Canada, they're generally fairly vague and malleable. So I wanted to give all that as a bit of context, but the question is why, if we're talking about technology, is all this important? And it's because underlying our concerns with technology is how they're being adopted and used to further these already problematic counterterrorism activities. So, the intersection of technology and counterterrorism and even national security isn't something that's, specific to the last 20 years since 9/11. But what we've seen is a very distinct interaction and intersection of the two over the past 20 years. And in large part, that's because of the growth of the use of technology and people being online and the use of more tools in our everyday life, and how that has also kind of dovetailed with the growth of these national security agencies and efforts to counter terrorism. And so that brings me to the second point I wanted to get into, and that's in what areas are we seeing technology, and particularly algorithms and artificial intelligence, being misused and leading to human rights violations in terms of countering terrorism and national security. There's a few examples both domestically and internationally. I think probably one of the best known concerns around technology and national security is around surveillance, and that was epitomized in 2013 when Edward Snowden, the former NSA contractor, leaked information about the global and illegal surveillance system being run by the United States in conjunction with its allies, including Canada. This surveillance, local and global, has defined in many ways what we've come to know as the war on terrorism. And the Snowden files show that Canada was no exception, revealing how the Communication Security Establishment, Canada's foreign intelligence agency that monitors all forms of communications, what's known as signals intelligence, was and continues to be an active participant in this global web of surveillance. Canada's domestic intelligence agency, CSIS, as I mentioned earlier, is also no stranger to these issues. So as I mentioned, in 2016, it was revealed that for years they'd been illegally retaining information about Canadians who were not under investigation, but whose information they collected during their targeting of actual suspects. So they would conduct this intelligence gathering about particular subjects, but at the same time, they would kind of scoop up all kinds of extraneous information about the people around them. And instead of disposing of that information, CSIS held on to it. Courts decided at the time that this was illegal, an illegal use of surveillance technology, but allowed them to simply hive off and freeze that information. And then just a few years later, with Bill C-59, the Liberal government legalized that kind of collection under the guise of what they call data sets. And so we see an illegal use of technology for surveillance and information gathering purposes, then legalized years later, and CSIS, instead of being penalized, being rewarded for this activity. We've also seen it with the RCMP, who've been found to be using controversial so-called web crawling surveillance technology to monitor social media and other websites for potential threats, but also using it to build profiles on individuals engaged in lawful dissent and activism. They were also found to be, and I'll talk about this more in a little bit in more detail, but they were also found to be violating Canadian privacy laws by using the controversial facial recognition tool Clearview AI. That scrapes the internet for facial images and uses algorithms to reach matches of potential suspects. And so we also see this technology used not just in the surveillance aspect, but also in the analysis of the data being collected. So as I mentioned, CSIS's goal of collecting those vast troves of information illegally wasn't simply just to have it, but to be able to analyze it and to run what they call big data analytics to determine who to surveil, who to disrupt. And as I mentioned earlier, all this is done in secret. And so if this technology, and technology is already being used so widely, why are we concerned about artificial intelligence in particular? I think it's important first not to overstate the impact of AI and the changes it will make. There's some interesting discussions that have been happening about how this kind of doomsaying about the existential threat of AI helps to actually shift our attention away from the very real and specific impacts that it's already having. But at the same time, it is a game changer in terms of how this technology can be used. We've seen it in how the public's been grappling on how to use ChatGPT. And we can only imagine the concerns about how it may be used to engage in identifying and targeting national security threats. We're also seeing this technology adopted very quickly around the world. In that same UN report, they also highlighted how counterterrorism and security were frequently being used to provide political and legal justifications or cover for the adoption of high-risk and highly intrusive technologies. So I wanted to talk about some of the very specific ways that we see AI already being used. But first, it's important to also say again how it's incredibly difficult to know how it's being used in Canada. And this speaks to why we need changes in the law. But it's also because due to the fact that anti-terrorism agencies are allowed to operate so much in secret. So already there are exceptions to existing transparency laws around the disclosure of contracts with third-party technology companies, exceptions for the adoption of rules around the adoption of privacy invasive tools or programs, as well as exceptions for responding to access to information requests or even seeking out warrants. And so all of this leads to a lack of information around how this technology is actually being used. But as I said earlier, perhaps the most well-known example is the RCMP's use of Clearview AI. I think many of you are probably very familiar with it because it was in the news so often when it did happen back in 2021. But just to revisit a little bit, Clearview AI is an American company that used questionable technology to scrape billions of images from the internet, images that they did not have the consent of individuals to collect, and that they then fed into a facial recognition system where they used artificial intelligence and algorithms to be able to match the images without any external assessment or determination about the accuracy or effectiveness of this tool. It was used by the RCMP for years, all in secret, and only came to light because the company's client list was leaked to journalists in the United States, and that included the RCMP. But until that point, they had actually even been lying to the media about their use of that technology. It never went through existing approval processes, even though those approval processes are weak. It didn't even go through those. And the RCMP has claimed that it was only used in searches for missing children, but this didn't match up with what the Privacy Commissioner found, because what the number of cases of use cases of the technology that they found from the RCMP didn't match the number of investigations the RCMP said they used it for. And so there's a lot of outstanding questions about what it was actually being used for by the RCMP. They've since stopped using it. But they're working and have adopted new policies on the adoption of new technology. But very worryingly, what they told the Privacy Commissioner is that they don't believe they have any obligation to ensure that third-party technology providers, such as Clearview AI, are following Canadian law. And so it's really stunning, and as I said, worrisome, because this means that they believe that they can contract any third-party technology without having to review its impact or compliance with Canadian law. And so it's a way to essentially skirt their ethical and legal duties by simply saying, well, we'll work with third parties. And this will come up again when I get into the specifics of ADA. So that's the clearest example, but we know that CSIS and CSC have also spoken about their use of AI. But again, they couch it in secrecy. They talk about adopting new technology and often euphemistically say that they're modernizing and want to modernize their investigative tools and approaches without actually speaking about the specifics of what they're doing. We do know, however, that the Communication Security Establishment just recently launched a grant program with NSERC, the national research body on science and technology, to work with students across Canada in developing new artificial intelligence tools. And so we know that they're working to extend their capability, and that they're doing so with the use of federal money and working with universities across the country. At the same time, these projects are confidential. We don't know what the projects are, and students need to sign non-disclosure agreements in order to carry them out. I have some examples of internationally, but I really want to get into the bill itself. So I think I'll kind of jump forward to what we see in ADA and why we need to bring in stronger rules. So one of the reasons that we're looking for new rules is around this issue of transparency, and that's what we call the black box problem. And so a key part of the justice system is, and accountability overall, is that decisions made by government and state agencies, especially when it comes to the deprivation of rights, need to be explainable so they can be challenged. But what we see is that the complexity of the factors being used by AI to make determinations means that it can't be easily explained. And that's even the creators of this technology have said that. And so if no explanation is possible, it's then impossible to challenge it. And we simply need to trust the technology, which obviously is something that we can't do. It's also an issue of ensuring that we root out bias in terms of how these algorithms work. So as I mentioned with Clearview AI, but as we see in other areas, that it's an issue of misidentifying individuals, especially for facial recognition, for example, that's biased and against individuals with Black and brown skin, against women, against the elderly, and particularly against Indigenous peoples. And we've been told that this accuracy can be addressed, but even if they no longer are biased along identification lines, we still know that there are fundamental problems and bias around who is targeted by this technology, and who fundamentally this technology will be programmed to view as a risk of committing violence. So with that, I'll move on to Ada, and I'll share my screen for this part. Let me just find it here. Just because I think it'll help to show some of the language in the bill and some of what I'm talking about. And if I just do, okay, is that showing up okay for everybody? I'm not hearing no, so I think yeah, okay, great. So as I mentioned, ADA is part of a broader bill to update Canada's private sector privacy laws, and that's very important to note. So it doesn't have an impact on public sector laws. So this wouldn't actually change the obligations, for example, of national security agencies, but it would change the obligations of companies that develop tools for those national security agencies, and that's a really important key part of this. So just briefly, so you know, there's three parts of the act. The first part is really about privacy, and that's the Consumer Privacy Protection Act. The second part is about the creation of a Personal Information and Data Protection Tribunal, which would be, it's a little complicated, but essentially it's a tribunal that would be put in place to enforce decisions of the review and enforce decisions of the Privacy Commissioner. So, maybe one thing that's important to point out is that currently the Privacy Commissioner, if they, for example, with Clearview AI, when they find problems with the infractions of privacy law, they don't actually have the power to enact fines or make any binding orders. They have to go to court to do that. But at least that Bill C-27 will grant new powers to the Privacy Commissioner to be able to do that. So, for example, in the case of Clearview AI, they can make a ruling and issue an order against Clearview AI, which they're not, aren't currently able to do. And the tribunal would be a body to that would review the commissioner's decisions. So it's controversial. I won't go into all the details, but there's actually a push to get rid of the tribunal part and simply allow the privacy commissioner themselves to make decisions, to make those decisions and not have to go to this tribunal that's appointed by the prime minister. And then finally, the third part is the Artificial Intelligence and Data Act. And so, overall, there's some concerns with the bill that it fails to deliver on defining privacy as a human right, and also that there's concerns about broad exceptions for collection and use of personal data. But I'll get more into the ADA aspect, and maybe we can talk about some of the other parts later if people are interested. So in the CPPA, the first part, we're concerned about exceptions that allow for private entities, so companies, to collect, use, and disclose personal information if the organization simply suspects that the information relates to national security, the defense of Canada, or international affairs. This is an existing law that is simply maintained in the CPPA in Bill C-27, and we're asking that it be removed. There's already provisions that if a company believes that an individual is breaking the law or plans to break the law, that they can report, that they can share information with law enforcement and national security agencies. So we don't see the need to have a vaguer and very broad exception in the bill that allows them to collect and share information simply on the grounds of suspicion, which is incredibly weak. And then the other part is the Artificial Intelligence and Data Act. So ADA would essentially bring in new regulations for the private sector that would ask them to assess the tools that they're creating for whether or not they're considered high impact. The problem, though, is that high impact isn't actually defined in the bill. It's left to regulation after the fact. And then also in the bill is the need to conduct an assessment. What needs to be in an assessment is also not included in the bill and also left to regulation after the fact. All of this process will be overseen by the Minister of Industry, which we find highly problematic because the Minister of Industry's mandate is for the promotion of the innovation of technology in the Canadian economy, and so there's a conflict of interest there between the mandate to promote technology and to hold it accountable. And accountability and assessment isn't always about promotion, and in fact could legitimately be argued puts the brakes on the promotion and development of that technology, as it well should. But that's not the mandate of the Minister of Industry. They would be able to delegate the powers for this regime to a new Artificial Intelligence and Data Commissioner. But unlike the Privacy Commissioner, for example, who's an officer of Parliament, the AI Commissioner would be named by the minister from among their staff, and would only have powers as delegated by the minister, and so would still be fully accountable and to the Minister of Innovation and work directly within that department. So even the oversight mechanisms put in place are incredibly weak. So we've identified some clear areas where they need to modify ADA. And that includes the need for public and adequate public consultations, the need for the proper oversight of ADA, so fixing the issues with the Intelligence Commissioner, that ADA must apply to national security, and I'll get into that in more details in a minute. The need for consistent technologically neutral and future-proof definitions, and this speaks to the fact that the definitions aren't in the bill, and we'll go through a regulatory process that in general is much less public, and often because it relies so heavily on the involvement of lobbyists, is usually part of what we call the regulatory capture process, where it's really industry that has the highest impact and highest input on the creation of regulations. And then the fact that there's absolutely no mention within the bill of the human rights implications of algorithmic systems. And so we've pushed that they need to not just have an assessment, but a human rights assessment. So what are the national security exceptions I mentioned? So there's a broad exception, which isn't surprising, that says that this act does not apply with respect to a government institution. And that's not surprising because this is a private sector law. It was the government never intended to cover the public institutions. There's a problem there. So as I said, it doesn't apply to government institutions. But more importantly, it says that it does not apply to respect to a product, service, or activity that is used under the direction of national defense, CSIS, the Communications Security Establishment, or any other person responsible for a federal or provincial department or agency who is prescribed by regulation. And this is highly problematic because it doesn't just mean that national security agencies aren't covered, but tools developed in the private sector for use by these agencies wouldn't be covered either. And so it essentially gives private sector companies a carte blanche to develop technology completely in secret for use by national security agencies without having to go through any form of assessment for risk or harm, or any kind of public accounting for the development of these technologies that are being used by organizations that are engaged in the riskiest of activities that can lead to actual lethal activities, in the form of national defense, or the undermining and violation of fundamental, human rights and charter rights in the case of CSIS and the CSE. And of course, under D, that they can add any other department by regulation, we would imagine that the RCMP would be added and others as well. The argument that the government has made is that, well, as soon as it's not being used by these agencies, for example, if a company then decides to sell it on the open market, then it would have to be assessed. But the problem is that it isn't simply that these could be on the open market. It's that there's absolutely no accounting for their use by government agencies. And so what we could see, and what we've proposed is that this be removed from the bill, or at a minimum that there still needs to be assessments, but maybe that they don't have to report it publicly, but they can report it to, for example, the Privacy Commissioner or to the National Security Intelligence Review Agency, because part of the issue is around confidentiality for national security purposes. But at the end of the day, what this means is that there's a severe accountability gap for some of the most harmful and riskiest technology that the government is allowing the private sector to, or not allowing, but that the private sector is developing. We also know that these tools won't just stay in Canada. If a company develops it for CSIS, they're going to try to sell it to other states. And so it's not clear if that counts as being on the open market and whether or not they then have to conduct assessments. And it's also possible that the Canadian government would just never know that a company, for example, there's a company called Sandvine that already creates technology that's being used by governments to illegally hack into the phones of journalists and politicians and activists. That is already being used, without control and in secret. So the government would never know that, if they're creating it for Canadian agencies, that then they're going ahead and selling to other governments. The only reason we do know is because of groups like Citizen Lab that do investigations on these kinds of things. And so I'll just leave it with the fact that, we did send a letter recently signed by 45 leading civil society organizations and experts calling for these changes to the bill. You can see the 6 areas there that we're asking them to address. We've seen some movement from the government in that they've at committee they've now said that they are committed to making certain amendments to the bill, including around recognizing privacy as a fundamental right. We're still concerned that they're refusing to recognize it as a human right, but it's a step in the right direction. And they're bringing in some more definition around what constitutes a high risk by documenting categories. But it still doesn't go far enough to answer the concerns overall, that this bill is vague. And also, fundamentally, there was no consultation with civil society organizations, and particularly human rights and civil liberties organizations, before this bill was tabled. There were conversations, but no formal public consultation. And much of what went into this bill was clearly came from the private sector. And so now we're playing catch up. The good news is that a lot of the members of the committee, especially opposition and even some backbench liberals, have recognized the problems and have been working with us to bring amendments to committee to try to fix the bill as much as we can. So I'll leave it there. I think that was a little long, but I hope that it it laid it out clearly, and I'm very interested in in your questions and any discussion. Thanks.
Thanks, Tim.
Thanks. Actually, I wanted to recommend a book if people are interested into this. There's a book called Your Face Belongs to Us. It's by Kashmir Hill, and it talks about Clearview AI. And I think the way Clearview AI works is, you upload a picture to Facebook, Instagram, LinkedIn, whatever, and Clearview AI, they scrape that image, take it, and add it to their database. And now you show up at a protest or something like that, the police take a picture of you, they can now match your face to that database. And in that book, they gave a couple of interesting examples, but one of the first investors into Clearview AI is Peter Thiel, who's a billionaire, who also invests in Planeteer, which is another company that does internet surveillance. But his daughter apparently was on a date with some guy he didn't know, and so he asked the waiter to take a picture of the guy that she's on the date with, so that he could look this guy up on the database and find out, is this a good guy or not. Another example, though, is Madison Square Gardens. The owner of Madison Square Gardens has access because they're worried about terrorists, that sort of thing. So they want to be able to block people if they're coming into Madison Square Gardens. But one other thing the owner of Madison Square Gardens did is they said, oh, there's these other people we don't like, which are these lawyers who have sued us for different lawsuits. So we should block them from coming in too. And there have been cases where lawyers go to come into Madison Square Gardens for a show. As soon as they get scanned, they're kicked out of the building. And the implication is, you can imagine if you're a union organizer or something like that, you get added to this database, you're going to be instantly identified and kicked out. So it's very scary, these kind of technologies, and I think there really needs to be legislative protection so it's not used against us. I mean, everyone in this room, we're all kind of troublemakers. We're all, going to be on some kind of a list, and so I think we should be very, very concerned about this. So I really appreciate the work you're doing, Tim. I know that wasn't really a question, but
thanks so much. And some of you might be interested. We're also part of another coalition called the Right to Your Face Coalition, along with the Canadian Civil Liberties Association, that's open for any organization to join, and is working specifically on issues of facial recognition, and in a much broader way. I focused in on national security, but the stuff that you just raised is clearly it's a deep concern, and that's some of the stuff that this coalition is looking at more broadly. So, for example, there was also the case of Cadillac Fairview malls in Canada using facial recognition to be able to evaluate emotional. They weren't looking for individuals necessarily, but the capability was there. But what they were trying to do is evaluate people's faces for their emotions, to then be able to cater advertising and other kind of services in the mall to what they thought they were feeling. But as you said, that it's a very small step from that to identifying individuals, and also not just identifying emotions that may make them a target for sales, but also for security, and for surveillance. We've seen this in France, where they're using not just facial recognition, but movement, broader kind of biometric surveillance, to try to identify whether or not an individual is acting in a violent way or an aggressive way, whether or not they're carrying a weapon or a suspicious package, all in the lead up to the hosting of the Olympics in Paris. And there's been some significant fights and court battles are playing out there right now around this, because the implications of trying to evaluate somebody's, movement for whether or not they pose a threat is very, it's dystopian is what it is. Yeah.
Chris Stevens, Canadian Union of Skilled Workers. Thank you for doing this important work. I think that there's a lot of really big challenges coming on the security and impacts around civil society. At the same time, from talking to workers that are out there, and I'm going to say, we talk about the working class, but there's a whole lot of people that are working class that we sometimes think about as white collar workers that are working class too, that are about to be or are already being disrupted. A lot of folks in the design space, graphic design, video production, they have found their whole industry basically destroyed. They're doing edit jobs now on videos instead of actually creating the videos and creating the product. All of those people are getting displaced and are going to be looking for work. And similar with lawyers and other key industries that thought they were safe, that were upper tier payments sort of categories. And I'm curious from your perspective, because you're looking at the regulatory space, but you're also seeing what's happening in the industry, where you see the big displacements coming, where you might predict some of the big changes in places where we might be looking for members and helping them reskill and find opportunities within the unions and the workplaces that we're involved in.
Thanks. Yeah, no, that's a very good question. Yeah. I have to say, that's not completely my area of expertise, but as you said, we've kind of been trying to keep an eye on the situation more generally. Certainly what you identified as content creators, is a big concern. Also, what we've been monitoring is, as you mentioned, lawyers. So using chatbots to provide advice to individuals, to provide service to individuals. There's a huge question about the types of assumptions that are built into those kinds of chatbots. So either for, as you said, for legal services, but for all kinds of other services, for evaluating access to loans, for example, in the banking industry, being used by governments to determine who can and can't enter a country, or by airlines about who can and can't, board a plane. So there's all kinds of questions about this idea of automated decision making that is going to be severely disruptive, and will certainly change the way that that workers interact with it, going from making the decisions themselves and evaluating it to somehow being able to monitor the activity and the results of these AI bots. And I think it's also important that that there's a recognition. So one of the things that we've come across in our research is, I think this applies more broadly, but for example, in counterterrorism, there's this idea that we can have this, kind of godlike algorithm that can predict the activities of individuals and can, funnel all this information in and make either accurate decisions or even be able to, narrow down and target to that level. And maybe one day it'll be there, but right now technologists are saying is that it's that level is impossible. And so this idea that we can use AI to replace human decision making and workers in being able to carry out these tasks is foolhardy. And if we do start doing it, we're going to come across all kinds of problems of bias, of discrimination, of decisions that simply just don't make sense. But that is, a cost saver, that can avoid, having employees, avoid having to pay for, real people doing the work. And so, there's a real tension. I think there's going to be a lot of, there's a lot of battles to come, especially because, these rules apply to high impact technology and uses of the technology. But there's all kinds of ways that aren't, necessarily high impact that that I think even you're mentioning, that will be impacted, that will be affected. And so what happens in those areas? And of course, there's a whole question of just generative AI, of AI that we can use to create new tools that aren't even covered or imagined by the laws that are coming into place right now. So it's a definite concern, and one that's not being appropriately addressed by the Artificial Intelligence and Data Act, or other government regulations.
Good afternoon, Will Christie from ACES. As part of the IT support staff at the University of Manitoba, one of the things we're being told is that AI is not going to replace us specifically, but people that know how to use AI are going to replace us. So I think on one hand, we do need to be cognizant that those are the tools, they're out there. We need training, so there are some opportunities. But if you're familiar, the old phrase garbage in equals garbage out, what you were just talking about, nobody has any specific insight to some of these tools, how they're using their determination, you know, how they're coming to their conclusions. And I think that this just underscores what you're saying, that we need more accountability, we need more oversight, and we need to really beef this up for everybody. You know, this isn't just a union specific matter. I think this is something that is pertinent to at least Canadians and to the whole global population. So thank you.
Thanks a lot for that comment. Yeah, no, I think, you know, we talk a lot about, you know, internet literacy or media literacy. I think, you know, there needs to be a discussion about AI literacy, about being able to understand, you know, how we can use it, how it is being used. And, you know, and training is going to be a big part of that. But also, you know, that's a really good point. We've been looking at the intersection of cybersecurity and surveillance and national security. So there's another law that's being debated now, or that will be debated at committee soon, called Bill C-26, which creates new federal cybersecurity laws. And it would grant, you know, really sweeping new powers to both the Minister of Industry and also of Public Safety to allow for cybersecurity measures to be taken, both by government agencies, but also by private sector agencies, or in private sector networks are deemed, you know, critical infrastructure. But at the heart of it is powers to mandate the communication security establishment to be involved in all of this. And so I mentioned them earlier, and they have this dual kind of role of intelligence gathering, but also of being Canada's federal cybersecurity center. And what we already know through court documents is that they don't see a distinction between their activities. So they use artificial intelligence tools to protect federal and critical infrastructure from cybersecurity attacks. But then the information that they collect when they do that, because they're always collecting information to identify, you know, threats, they then view as being fair game to be used in their signals intelligence operations. And so, for example, they have a contract with Global Affairs Canada to provide cybersecurity, but then they also say that any information they collect there, they can share with their Five Eyes, which is Australia, US, the UK, and New Zealand and Canada, that they can share that information with the Five Eyes and other international partners for national security purposes. So our concern is, you know, these AI tools that can very well and are very effective at helping, you know, prevent cybersecurity, you know, cyber attacks, and that we need to be using, but that there's also a lack of protection to ensure that that's what it's being used for and being targeted for, and that can't be used for broader kind of government surveillance purposes. You know, and I try not to sound too, you know, dystopian or you know, conspiracy theory, you know, like I don't, but at the same time, we've seen enough cases where the government has misused individual information that, you know, even for that one case of abuse that goes so horribly wrong, we need to make sure we have the protections in place to make sure that it doesn't happen.
Hi, Tim. Thank you. My name is Ghislaine. I'm also with ACES. I just quick question. Have you heard of or have you worked with an organization called Open Media, who also advocates for similar protections for citizens?
Yes, yeah, we work quite closely with Open Media. They, you know, were part of the group that drafted the open letter. that I mentioned. And yeah, so we've had kind of an ad hoc network of organizations that have been working on this together, and they're not a member of the ICLMG coalition, but they're a group that we work with closely. Yeah. Yeah, and I encourage people to check out their work.
Okay, I don't think there's any more questions here for you, Tim. I really appreciate you taking this time on a Saturday to be with us for all the work you do on all our behalves and on behalf of CCU as well. So much appreciated. Thank you very much.
Thanks so much. Thanks so much for having me. I really appreciate it, and it's always great to be able to come to these meetings, and the questions and discussion is always really kind of interesting and engaging. And so thanks for all that you've brought up. And I didn't put it in here, but you can reach us at iclmg.ca, or my email is nationalcoordination@iclmg.ca. Maybe that can be shared later on. But I'd be happy to follow up with anybody if you have more questions or want to get involved with that Right to Your Face coalition, or with any of the other work we're doing on ADA. And on our website, you can also sign up for our newsletter. We send out every 2 weeks, we send out a news digest covering these issues, and news articles about issues of human rights and national security and counterterrorism. So yeah, if you want to stay up to date, you can sign up for that too.
Okay, thank you.
Thanks, everybody.
All right.
Have a good afternoon.
You too.